Good evening.
Tonight, a new emergency motion in the trial we've been following. 3 competency evaluations now pending in one Ohio family case. And Brian Kohberger's own defense expert may have already examined the evidence he's now building his case to withdraw his plea on. This is the particulars.
The trial watch.
This is the Lindsay Clancy trial. Quick reminder for anyone just joining. Lindsay Clancy is on trial for the deaths of her 3 children, Cora, Dawson, and Callan. She's never disputed that she caused their deaths. The fight is over her mental state under Massachusetts' lack of criminal responsibility standard, the formal name for what people usually call an insanity defense.
Today was Patrick Clancy's second day on the stand as the prosecution's first witness. His testimony concluded today. Court resumes Thursday with the next prosecution witness.
So the jury heard the 911 call Patrick made after finding his children. We're not going to describe its contents beyond what's already been reported by name in the courtroom press. The recording itself and the autopsy photos are impounded under a Supreme Judicial Court Rule 119 order. Judge Sullivan's order is explicit. Media cannot record, display, reproduce, distribute, or otherwise disseminate either. What outlets in the courtroom have reported is that Patrick can be heard telling the dispatcher, quote, "She killed the kids," end quote, and that he described, quote, "blood everywhere," end quote, when he found them.
Yeah, and if you've seen images online claiming to be a transcript of the 911 call, don't trust them, and we're not using them. That order blocks reproduction of the actual recording. Anything circulating outside of what named news outlets in the courtroom have reported is either violating that court order or unverifiable. And we're not going to be the ones repeating it either way.
And I will say also on that note, because there are a lot of things going around. What happens a lot of times with stuff like that, when the judge orders something saying that, you know, it can't be reproduced and things like that outside of court, you will see people that were in the courtroom give their version. So while I'm not saying that parts of what you're seeing online aren't true, I'm just stating that as it was not to be, you know, reproduced and things like that, I didn't feel comfortable even kind of like covering what was in some of that that's going around.
The judge's order, the court order made sure that, hey, only this information that's coming from this specific source should be verified. But also today, Assistant DA Jennifer Sprague held up the exercise bands prosecutors allege used to strangle the children. The first physical evidence beat we've had in this trial. And testimony touched on Lindsay's attempts to seek mental health care in the months before the killings.
So, okay, I will go ahead and say this part. The testimony touching on Lindsay's mental health care attempts is evidence the defense relies upon for its postpartum psychosis theory. So keep that in mind as we continue to go through some of this. And we also went back and confirmed 2 details that have been floating around unverified. First, defense attorney Kevin Reddington told the jury directly in his opening statement exactly how severe Lindsay's injuries were. Quote, "She shattered, exploded her thoracic spine, shattered her cervical spine, first disc, broke every rib," end quote.
Yeah, and the first disc of the cervical spine is way up by the skull. It's right at the base of the skull.
And I will say that that was a direct quote from the courtroom coverage.
Yeah.
But because there's a lot of different things, again, with all this stuff, that's what's crazy about the trial. As you see, so much is just mass produced. Like, you may have some verifiable things, but then it's like people take it and run with it, and it just becomes, so that's why I feel like it's very hard to trust a lot of what's going around.
Yeah, because any outlet is going to try to grab something and glorify it, dramatize it, and have a story. and that's what gets their ratings and gets their views.
So I will say that these specific things that we are talking about right now, we did cross-verify those.
Secondly, on redirect, Prosecutor Sprague asked Patrick to confirm the drop from that second floor window to the ground is 12 feet. He testified he had never personally measured the distance. When asked whether it was approximately 12 feet, he said he believed that was correct. That citing that was the window height figured 12 feet via Sprague's redirect question to Patrick Clancy, and that was covered on CNN Live.
And separately, this one came up off air this week, and we want to say it plainly rather than let it float around unverified. Lindsay Clancy is paraplegic, paralyzed from roughly the sternum down since that fall. Reddington has told the court directly she requires a two-person assist for transfers to flat surfaces, and that her medical team has flagged a real suicide risk requiring constant supervision. That's not speculation. That's Reddington's own on-record statements to Judge Sullivan. So moving on to the emergency motion. So Tuesday, the trial actually paused for a day. The scheduled jury trial event was canceled by the court. That's because the defense filed an emergency motion asking Judge Sullivan to instruct the jury to disregard specific portions of the prosecution's opening statement and Patrick Clancy's early testimony.
Specifically, two things. The defense wants the timeline of when the children were killed struck. And they want any reference to Lindsay searching ways to kill struck. Reddington calls that an ongoing false narrative. And attached text, he says, from prosecutors, characterizing her search history that way.
Attached to that motion is an affidavit from a digital forensics expert, Stephen Verono, who disputes the specific dates and times attached to some of those searches. So as of this afternoon, there is no ruling yet from Judge Sullivan on this motion. We're reporting it as filed and pending, not decided. So this is like a live example of exactly what we talked about Monday in Legal Minute, that an opening statement oversold or built on disputed facts can have real consequences. We're watching that play out actually in real time.
And this trial watch, if this is the kind of discussion you've been looking for, tell your friends, hit the follow. We do this every Monday, Wednesday, Friday. And we're tracking this trial start to finish, barring any catastrophicness that will keep us from being able to do it. But we've let's just say we've been through a lot this past week and weekend, and we're still here.
Yep.
Trying to be here with you, trying to get this information across.
And we appreciate each and every one of you
absolutely
that likes, follows, shares. That means the world to us, and we appreciate all of you. And while we love doing this, one of our biggest things was we wanted to be able to give our analysis and in a way that is maybe easier for people to understand.
Yeah. And there are going to be some things where we don't have an opinion or an analysis on. We're going to present the facts, and it's going to be outside of our purview.
Yeah, I agree with that.
We are not attorneys. We are not, yes, I'm a former federal agent, and Lacey, she is a licensed PI, but a lot of this stuff we are learning as we go. So some of the stuff that's going to be out of our purview, we're not going to touch on, and we don't really want to give our opinion because obviously we don't want to make fools of ourselves.
I try not to discuss things that I don't have kind of a general understanding of.
Right. So we're going to cover some housekeeping since Monday.
Yes. Everything we've got lives in one place, our link tree. Link in the bio. Schedule, coffee, the Sticker Mule store, every social, one link. And I will say as a follow-up that I did get another email that I was thinking that today was going to be the day that my t-shirt was in, and I am sad to report. It shipped. Okay, good. Mine has shipped, and it was supposed to be delivered today, and yesterday I got a notification that it's going to be here tomorrow. So maybe I will have the t-shirt to show you live on Friday. I'm hoping. But again, anybody that is interested in stickers or t-shirt that is on our Sticker Mule store, I think it is a really neat design. I don't know. Amy bought it, so
good.
I think
Thank you.
She's gonna like it. But anyway.
Quick production note. Then a couple of updates on cases we've covered before.
Yep.
We've kind of changed our production a little bit. You'll see that we, what was it, last Friday, I believe?
It's ever evolving.
We moved to a 4-segment structure.
Yes.
And you kind of saw that in the very beginning, where we have our 4 different segments. We also have a housekeeping within that. And we open the floor to the chat and to the viewers.
So we are touching back in with Nancy Guthrie. So she has been missing now for nearly 6 months. Her daughter, Savannah Guthrie, released a new public video plea this week, and Pima County Sheriff Chris Nanos gave fresh on-record comments saying the case remains active and that he's, quote, still positive, end quote, it'll be resolved. So we're not going into the ransom note authenticity claimed or the hidden message theories circulating online right now. Those are single source and speculative. And we, like we've said before, we try to cross verify and give you specific sources. And most of the time, like if I can't find the source for it, I'm like, I'm not putting that out there.
Nope.
So that's why we didn't cover that. But now, I don't know how you always end up with this one.
I wonder. Who writes all this stuff? On to the Tate brothers. If you don't know, Tristan and Andrew Tate, the federal prosecutors are seeking to keep them detained while the extradition proceedings continue rather than release. And a status conference has been set to schedule the fight itself. Their attorney separately claims the brothers face threats to their safety in the Miami jail. That's the defense claim, not independently confirmed. So the UK is trying to extradite them back to the UK, and the FBI is involved.
I will just say on this, though, with high-profile cases, which we're going to actually kind of touch on this in a minute with something else, but a lot of times with high-profile cases, like I'm not trying to be anyway or throw shade at anything, but when we put out, so like say we're going to do we're going to put something under seal, I do think there are a lot of valuable reasons that we would seal things. However, in some cases, just because you are a celebrity or something like that, I don't necessarily think that's, but in terms of some of these cases, it is extremely hard.
So annoyed with sealed records.
It's extremely hard because it's, again, like we've talked about this on another one of our episodes. It's like, how am I, you're basically telling me that I have to take somebody else's word for something.
Yeah.
And I don't like that as a person because I want to verify. I want to know.
It's not that we want the tea. We just want to.
I just don't believe.
Know.
I don't want to. Yeah,
information and knowledge is power.
I don't believe a lot of things. I'm like, okay, show me. That's great, but show me where that came from. How did you get that information? Yeah. Why are you saying that? And it's like when you say, well, just believe me. No. And with a lot of some of these, well, again, more so the high profile cases.
Yeah.
It's like, well, you just have to take our word for it. Well, all right, I guess. But
okay, if you're watching this as a clip and not live, follow it, like it, share it, and check the coffee and sticker mule links in our link tree.
And now we're going to go on to our next official segment, which is segment 2, the legal minute. Massachusetts, Kentucky, Pennsylvania, and Virginia are the 4 commonwealths in the United States. It's a historical, traditional title written into each state's own constitution, not a different legal status. Functionally, legally, constitutionally, identical to state.
Mm-hmm. And that's why the Clancy case is captioned Commonwealth versus Clancy instead of state versus Clancy. Same reason it's Commonwealth versus McCool. Macau, sorry, and the 1967 case that actually sets the legal standard we've been citing all along. And it's the same reason the Conley case out of Kentucky is Commonwealth versus Conley.
That was a lot of
I know.
One little.
Not a typo and not a different kind of prosecution. And I believe that when we were having this discussion about
but details
the state,
matter,
the
sir.
prosecutor,
but it's not the state, it's the Commonwealth.
And we just said it's identical to state. So we don't want to confuse anyone.
Right.
When we say Commonwealth, think of it as state versus, because that's more familiar. Like we just said, only 4 states in the nation are referred to as a Commonwealth when it comes to criminal cases.
And it just so happens that there's been some very high profile cases, trial watches in Commonwealth areas. So a direct appeal challenges legal errors made during the trial or sentencing itself. Brian Kohberger gave that up, waived his right to a direct appeal as part of his guilty plea.
Post-conviction relief is a separate, narrower track. It's typically built on ineffective assistance of counsel, an involuntary plea, or evidence that was withheld or newly discovered. In Idaho, the bar to actually get a conviction set aside this way is high. Courts can only do it to correct a manifest injustice.
That's the path Kohberger is pursuing now, after waiving his direct appeal right as part of the plea agreement. Keep that in your back pocket. We're about to walk through exactly what he's arguing, which leads us into...
We are skipping, I believe, to red flags. She's always throwing me off. Always.
It makes it interesting.
So we bring up some red flags about something we deliberately didn't use. Segment 4, we're skipping segment 3 for right now. What red flag? What we won't touch. Earlier this week, Lacey was shown images claiming to be a transcript of Patrick Clancy's 911 call, the one impounded under Judge Sullivan's Rule 119 order.
We didn't verify it, we didn't use it, and we're not going to describe what it said. That order specifically bars reproduction of that recording, and even setting the legal risk aside, we had no way to confirm it was authentic. And I'm going to even push back one more with this. I'll let you give your little thing, and then I'm going to give you another example of this, because I did this twice this week. Go ahead.
Oh, I thought you were going to.
No, I said go ahead, and then I'm going to give you my other one that falls right into this.
This is the same instinct behind every sourcing tier we use on this show. If we can't trace something back to a named, credentialed source who was actually there, it doesn't go on air, no matter how interesting it looks.
Now, I say all that to say that I am a keeper of things, okay? And I was also sent very early on a text image of Brian Kohberger's handwritten plea.
And what did he call it? Do you remember?
I know, but what I looked at it, I was like, wait, what? And then I was like, I immediately go like to the World Wide Web, and I'm like trying to source this. I go to the docket, I'm like pulling up all these things. I'm like, this is nowhere. And then I'm like, I'm not saying a word about this on the particulars, because I don't know. I mean, I know where it came from, but I don't know, like, I'm thinking, how did this get?
We can't verify it.
Yeah, I couldn't verify it. But then you started seeing that people had taken the image of the handwritten and they had transcribed it.
Krista, thank you for the follow. We greatly appreciate it.
And I was just like completely blown away that I'm like, first of all, I can't verify the image. And now all I'm looking at now is your transcription of the unverifiable image. So I'm like, how many unverifiable items do we have? And it was just like TikTok video after TikTok video and Facebook post after Facebook. I was like,
they're all running with it.
And I'm thinking
it could be completely fictitious.
I will say it was his letter, but
so you did verify?
It's come out now. Yeah. Okay. Did anyone see me post? No, I didn't post about it because, so again, I look at things and while, because actually it was somebody had sent it and they're like, what, is this real? And I'm just like, well, I've never seen this. Like I watched, this is unrelated, but not. So I watched A Cinderella Story. It's one of my favorite movies and I watched it and there's a part where, it's Jennifer Coolidge, right?
Yeah.
And it's like the end of the movie, and she's like, I'd never seen my husband's hidden will before. And it's kind of the same thing. It's like, I've never seen this document before. Like, sorry, that was probably not, that was just, it is what it is. I thought it was funny. Like, it makes me giggle. It's like, I love Jennifer Coolidge. She's one of my favorites.
Right. So this leads into the segment we skipped.
And now you see why.
Evidence of the night, Kohberger's petition. One disputed piece of forensic evidence, 2 accounts, what the record shows.
So, 1 year after pleading guilty to murdering 4 University of Idaho students, Brian Kohberger is trying to take that plea back. He filed a petition for post-conviction relief in Ada County District Court, case number CR 01-24-31665, the same case where Judge Stephen Hippler accepted his guilty plea and sentenced him to 4 consecutive life sentences without parole.
Adding on to that, the heart of his claim.
It was like the same time. I did a heart, but it was...
He says his attorney didn't properly disclose or investigate exculpatory evidence before he pleaded guilty. Specifically, he points to what he calls clumps of unknown hair found in Ethan Chapin's hands.
Here's where it gets genuinely complicated. Not because we're being cagey, but because named sources are describing potentially different hair evidence in materially different ways.
One account from People magazine citing court documents unsealed earlier this year. Kohberger's defense retained forensic expert Ruth Ballard, reportedly examined hair recovered from Chapin's right hand and found it morphologically consistent with Chapin's own reference hair. That's not a DNA match or a unique identification. A morphological comparison looks at visible physical characteristics under a microscope, meaning, according to that account, his own expert looked, and what they found was consistent with Chapin's own reference hair.
So a different account from former FBI profiler Christopher Whitcomb's book and forensic expert Brent Turvey's public statements describes the hair roughly 6 inches, dark blonde with a reddish tint. That was allegedly never tested by authorities at all and doesn't match Kohberger's own hair characteristics. So we genuinely don't know if these 2 accounts are describing the same hair sample or they're 2 different ones. And at least one outlet reporting on this has said outright it hasn't independently reviewed the underlying lab documentation. At this stage, we cannot independently determine which account is accurate because the underlying forensic documentation referenced by both competing reports has not all been publicly produced. We're reporting the discrepancy, not resolving it for you.
Idaho's own reporting includes a local attorney, Ryan Black, calling the whole theory a long shot. Quote, grasping at straws, in his words, given how much evidence was already on the table before the plea.
So for context on what he's actually serving, the docket itself shows 10 years for burglary plus 4 consecutive life sentences, each explicitly with no possibility of parole, and he still owes over $300,000 in restitution and fees. That's the sentence this petition is trying to unwind.
So we're going to call back the Gonzalez family's prior statement, calling the filing the mosquito you just can't seem to swat. It kind of still stands and is worth a quick callback here.
I will say that, setting aside the merits, I think this is a genuinely useful case study and how a single piece of evidence can be described two completely different ways by two sets of credentialed people, and why primary source or didn't happen matters even when the source material is contested.
Right.
And I think that directly links back to, and I should have pulled which episode that was, but we talked about it in one of our episodes, where expert witnesses.
We did. That was one of our red flags.
And we were talking about expert witnesses.
I believe that was Friday.
No, I think it was before that. Because somebody had asked the question. We were talking about the witnesses in this case. Well, maybe it was Friday because we were talking about the trial watch.
Yeah.
But anyways, in terms of expert witnesses, no, it was when we were talking about Scott Peterson. Because we were talking about the documentary.
Was it?
I'm pretty sure. I could go back. But with that, what I was meaning to say, squirrel, was that you can have different expert witnesses that say completely different things.
Right.
And that is how you have, so for this situation, the Commonwealth versus, the prosecution, or in Idaho's case.
I remember it was Peterson's case.
Yeah. See, so
it was the FBI.
Hydrologist.
Yes.
Oh,
yeah.
I was thinking the hydrologist. Is that
versus the state's FBI analysis that was done.
So there's a lot. You will see that because, again, and we do also have like standard operating procedures. So depending on which, lab does what and things like, so there's a lot of different variables that kind of go into play with some of that. And it's expert witnesses, I think, is a very loose term. I say that because there could be an expert.
Essentially, they have to have or be able to present to a jury that they have
like extensive or beyond,
knowledge than what even a person studying that would. I mean, and not only that, but to be an expert witness, a lot of times it calls for you to already have testified, not in that particular instance, but in similar cases.
Well,
for those type of things.
A lot of times you will find, so like an expert, they don't necessarily have to be like a PhD or, they don't have to be like a doctor or anything like that, but depending on what the topic is. But like you could have like a firearms expert, and that's literally that day in and day out for 50 years, they dealt and handled and, they have extensive knowledge of firearms, and not just like one, and it's like firearms, I can't think of anything, but
for instance, a case that we covered in our Casewalker Chronicles season 1, the defense attorney for Richard Allen, and I know this isn't part of any of what we're talking about tonight, but I just want to bring this in with the subject matter expert. The defense brought in, or tried to bring in, an individual whose title was called a metallurgist.
Oh, yeah.
Which is a true science of the study of metal and how the properties of metal are studied. And that was it was very interesting to me, and it makes sense because if you've ever watched the show, I can't remember the name of it. They make blades. They make knives.
Oh, Forged in Fire.
Forged in Fire. Those people technically are metallurgists because they use different types of steel and different types of alloys to bond and fuse together. Why didn't
you say that? When we were first going through like that specific trial, and when we were talking about witnesses and they were like a metallurgist, I looked at Nick and I'm like, what is a metallurgist and why would we be having this person? I've never heard of that.
Because
now, if you would have said something like
with that case, and this again, this is a tangent. I'm sorry, but
it's a direct relation.
When we're talking about subject matter experts, it gives you an idea of kind of what.
And there's so many narrowed lanes.
Yes.
So that,
But I will say, in that case, the judge suppressed that.
Because.
We're not going into that.
No, I'm just saying. No, what I was going to say, I'm not going to say what I was going to say. I'm going to say something that actually falls along with that. A lot of times, in terms of science, you will hear things like junk science.
I hate that term.
And it is because, now, I'm sorry, I think science in general is like, if it's scientifically proven, to me, I feel like that's...
Yeah, but science is theory. Science is hypotheses that are tested.
Tested.
Yes. But tests are subjective.
But I don't feel like they are. Like, I feel like, I'm trying to think of an example of...
Well, a metallurgist. That's a perfect example, because with that particular instance, that individual had extensive research and knowledge in how a particular alloy can cause particular markings on a different type of alloy. To be more clear on that, how this type of steel can make this type of mark on this type of brass. That's metallurgy.
Yeah. Which I think that is actual science.
It absolutely is. It was suppressed.
I think there are situations, for example, where we talk about things like a polygraph test.
Oh, gosh. Don't. We're not
getting
started on that
science.
It's the same.
You want to get on your soapbox?
It's the same as a drug dog sitting on a car. Junk science.
Okay, well, I will agree and disagree, but what I'm saying, and here's what I'm saying, because I, as somebody who does and favors psychology over a lot of things. So when we break apart, and maybe one day we'll talk about polygraph tests. Okay, but if you ever come at me and say something about a polygraph, I'm gonna be like, no, I don't care what it says, because, and here's why. My understanding, I am not an expert, so I am not an expert in what do they call a polygraphy test or examiner or something like that. I am not that person, but I can tell you the psychology, so to speak, behind it. So,
I've actually been through two.
Basically, it's a biological reading, or like the biological functioning of your body, so to speak. So,
and it's more than biological too. It's physical analysis by the examiner.
Again, so
which is subjective.
Exactly. Point right there. But what I'm talking about, so you say, for instance, someone who is a pathological liar, who is constantly lying and doesn't really
they're not going to have the same physiological reactions as someone who is lying.
Right. Like for me,
because they know they're wrong.
I can't lie.
Yeah.
I cannot lie. So for me, if I took that test, it would be very, very factual, because if I was lying, I would have a response that would register on the machine. Therefore, it would be a valid. But I don't think that you can
that's why you get a lot of polygraphs that come back inconclusive. They don't come back to exonerate somebody because they can't. They've already they've already established in law that polygraphs cannot be admissible.
And because I think it requires the interpretation from someone else, which is exactly, I will give you the link to the dog science, because it requires the interpretation. So therefore, apples and apples,
right?
They're the same. Anyways, what I'm saying is, with science, a lot of times, the reason people label things as junk science is because there's not like a standard.
Right. And we got off of the subject matter expert stuff a little bit.
No, it wasn't, because it directly ties to
our
expert witnesses. And when you have witnesses that are contradicting each other, and then you can understand why in cases you have defense experts,
yes,
and you have state or Commonwealth experts.
Yes.
And they are going to find the expert that speaks, so to speak, to their theory, narrative, story, whatever word you want to use, strategy. They're going to put people in place to verify or corroborate their side.
Yeah.
So that's my thing on expert witnesses, is I think you could find an expert witness for anything.
Yeah, ultimately, yeah. If you've studied it enough.
And there's somebody out there. I mean, like, what is it? Is it etymology, the study of bugs or something? Is that?
Yeah.
Like, so I mean, there's somebody out there that studies everything. You could find somebody, but again, it's you in terms of that. Like if I'm talking about like with the metal thing, okay, great, yeah, you say that does that. I'm sure you've seen it do that. I will take your word for it.
Right. Thank you so much. Tap the live event on our profile and register. TikTok will notify you the second we go live.
Which I don't know if it does that. One of these. I don't know if it does that anymore because
it's supposed to.
Nick goes through OBS.
Well,
and I don't know that it does
it. I go through the TikTok Live Studio. That's the program that I use. It's not through the phone, like the TikTok app.
Yeah,
on
but that does. If you do it through that, you can create an event.
It's supposed to. If you want to support what we do here, take a look at the merch store. We do get a small commission off of the shirts that you buy. It's not much, but everything that we do get goes to help fund our production here, our research.
That is one of those things, like subscriptions, document fees.
Yeah. It's expensive.
There's a lot. So if you, in some court systems make you do, I think it's like 10 cents per page.
Yeah.
And depending on the, well, yeah. So that is what we mean when we say the funding goes to that kind of thing, because those are ever growing.
Yes. Tonight's recap of the segments we started off with our trial watch.
Yes.
Still looking at the Lindsay Clancy case. And from there, we moved on to our legal minute. And Lacey made me jump around from our typical evidence of the night.
What was our legal minute, though?
Red flags. Our legal minute? What did we cover in our legal minute?
Tell me.
Do you remember?
Yes, it was the Commonwealth not Commonwealth versus state, but
right.
And
specifically.
Then we also talked about Kohberger.
Right. But Kohberger was part of our red flags.
Yep.
And also in our evidence of the night. We kind of swapped those up tonight and changed it up a little bit. But we still had all 4 segments in tonight.
Yes, we tried to get them to flow so that hopefully by the time we discussed Kohberger's filing, it made a little bit more sense. So let us know all of your feedback. And again, share.
Yeah, feel free to reach out to us.
Yes. And the replays are on YouTube. And if you are on YouTube, you can subscribe. I think it's subscribe, right? Or follow?
YouTube, subscribe.
Yeah. And TikTok is follow. So,
Amy, thank you for being here.
As always, headlines end.
The details begin.
We'll see you Friday. Follow, share, find everything else. Our opinion.
Our analysis.
Not legal advice. Thanks for walking the case with us. We'll see you soon. Night, guys.